YouTube, it's Tom. I'm back with another one for you. Now, this one here is the Foreclosure Defense Handbook. This is the sixth video on this particular book here. And yeah, so we're just about wrapping this book up. Maybe got 3 more videos here left to do on this, and we'll be wrapping this up. So let's get right into this. So right here we're talking about different examples of lawyers that you could find to help represent you, and we'll get into a little bit about what the word represent means and kind of break it down quickly. So here it says, so here's why you may not want the most experienced and sharpest one that you can find. Because they are often in high demand, they don't need the work, and they don't have the time to properly prepare and research a case. Instead, it might be better to find a friendly attorney and bring him a case with solid arguments, solid evidence, and solid laws to back it up. All he has to do is to massage it a little bit. All you have to do is make sure that he is actually representing you, which means speaking on your behalf. So right here it says, by the way, represent actually means represent. So your lawyer represents you into the court system as a legal fiction and not a person of flesh and blood. They talk because you can't. They call people like you incompetent in the same way a quadriplegic or 6-year-old child is incompetent. Your legal fiction is your name spelled in all caps. It is not you, but it is a representation of you, much like a drawing. All governments, banks, and legal entities around the world can only interact with the legal fiction version of you. Welcome to the Matrix. And you guys know we're in the Matrix, and if you don't believe me, look at the community section, look at the gematria breakdowns, and tell me what you think. If you want to argue with mathematics, then that's on you. So one way to weed out crappy lawyers is to give them this book and ask them to read it. We have written this book with the purpose of not only exposing the fraud, but also showing lawyers how to argue the case. A good lawyer can take what we have presented here and do their own research to support the arguments presented here. If they are not willing to read it or demand that you pay them for their education, then you might want to go to someone else who you might want to work with. One key point you want to enlighten potential lawyers you intend to work with is that this is a major growth area of law. If they learn the arguments of foreclosure defense, they will likely have a lot more business and a huge competitive advantage over other lawyers in town. Again, there are likely good lawyers out there. Unfortunately, many of them are often booked up and hard to find. The advantage of a good lawyer is that they can prepare your arguments, make sure that they are legally sufficient, and be able to represent you in court. Since he should have experience in the courtroom, he would know what to say and what to do. As boring and as weird as it may sound, learn to love the law. It is there for you. And it says if you're looking for a lawyer of a good one, or you can refer other one to members, and then there's a link here that when you ask for the book, I'll give it to you. You can go ahead and click the link there and scroll down there. If you want to add to it or find resources for lawyers and shit like that, you can find them there in the book. Okay, so it says do it yourself. If you can't find a good lawyer, or if you can't afford a lawyer, or you can't find a good one to work with, the next option is to do it yourself. This is known as pro se or pro per in California. So more and more homeowners are choosing to do it on their own. Frankly, this information is so exotic and so new that few people can rely on lawyers to support them. Let's be clear, this is not easy. This could be one of the most demanding things you have ever been asked to do in your life. Don't do this. Seriously, this is not a standard disclaimer. Don't do this. The litigation process is not for the weak of heart. It is better that you find other solutions than to litigate against your lender half-cocked. It is like a fly hitting a windshield. It is not pretty if you don't know what you're doing. That said, your home is everything. Without it, you are lost. You are ungrounded and uprooted. Your family is unsettled. Now that you know about the fraud, you have to decide whether you are willing to fight for your rights. However, if you do decide to do this, you will have to commit to doing it to the very end. As Yoda says, do or do not. There is no try. We have to put together a coaching membership program to help with homeowners' resources so they can do this on their own. So, and you know, it is what it is. Like, personally, I'd rather not. If you don't have to fucking argue with them and all that shit, then don't. But in all reality, let's be real. These people are dying to fucking steal your house. So the likelihood of you having to stand up for your rights are pretty goddamn high. And the likelihood of you finding a lawyer that's going to be willing to fucking put his bar membership on the line to fight for your house is pretty fucking slim, to be honest with you. So our membership program allows you to connect with other homeowners so that you can support each other, share and collaborate on ideas. As a benefit of the membership program, you will also receive sample documents that you can use to challenge your lender and fight for your rights. Other benefits include access to sample responses. Once your lender responds, we have samples used by others in our programs you can use to craft your own responses. Legal resources. We will show up and we will show you where to look for local laws that apply to where you can find people and help prepare documents to understand this process more. So it says here, let's be clear, this is a membership to a homeowner support club and not a substitute for good, competent legal advice. You should seek competent legal counsel where possible. And he says, sorry, I'm required to tell you this. And the Bar Association has a monopoly on the legal franchise, which you already know it is. You know that shit is a fucking monopoly. So here it says, help, my house is up for sale next week. You know how many fucking people hit me up talking about their house is up for sale next week, or they hit me up after they fucking got themselves into some serious fucking bullshit and expect me to walk on water to get them the fuck out of there, and then they're gonna try to take it out on me when I can't fucking pull them out of the hole that they dug for themselves. That shit is amazing. I think it's fucking hilarious, to be honest with you, but what are you gonna do? So, help, my house is up for sale next week. If you find yourself in a situation where you're about to lose your home, you have two options legally. One is to file a civil action against the lender, followed by a motion for temporary restraining order, TRO, and injunctive relief. The other is to file for bankruptcy protection with an automatic stay. Firstly, in order for a TRO or an injunctive relief to be granted, the petitioner has to show a strong likelihood of success. This means that as a plaintiff, you will need to bring compelling evidence to convince the judge that you deserve a stay of the sale. It is your job to bring significant controversy that brings doubt as to who the real party of interest is in the foreclosure action. Obviously, having a securitization audit would be hugely beneficial, as well as the pleading complaint that argues the points and the authorities that the lender is not the real party of interest. However, this takes time that you might not have. Crafting a pleading takes time and requires great care. It is not something that can be rushed. You should consult your lawyer as to the proper method and process for this. If you are a member of the Foreclosure Defense Membership Program, we have included sample TROs, injunctive reliefs, as well as sample pleadings that others have used. It is up to you to customize the argument as it applies to your own situation. Be warned, you do so at your own risk. These sample documents do not come with any assurances whatsoever. Sadly, TROs are rarely granted. The plaintiff has to bring an overwhelming amount of evidence to cast significant doubt to the judge for one to be granted. So, you know, obviously, you would probably want to reach out to them prior to all of that, asking them for all the evidence that that shows that they are the real party of interest, for one, and then two, that they even lent you money to begin with. And then three, you know, proof that they have not, in fact, securitized the promissory note and sold it off and pooled it with others to be sold on the Securities Exchange Commission market, right? So the bankruptcy automatic stay method. To buy time, some homeowners declare bankruptcy. When you declare bankruptcy, you receive an automatic stay from all creditors, including the lender. Many homeowners feel this is the best and most assured way to stop the sale from happening. Be warned, bankruptcy is not for the weak-hearted. Do not enter bankruptcy lightly. You will need to declare all of your assets, income, and financial details. It is like having a permanent anal probe of your financial details. It is not pleasant. Never ever lie. Especially in bankruptcy court, you will go to jail. As great as the temptation to hide the precious little money you had from your creditors is, don't do it. The other downside of bankruptcy is that it is a mark in your public credit score. But frankly, having a bankruptcy or a foreclosure these days is not as big of a deal as it once was. Almost half the country has been through it. It is like being a leper in a leper colony. It's not as big of a deal anymore. The fact is, however, for most homeowners, this might be the only way to keep their house from the auction block while they buy time to build their case for the foreclosure defense. The other thing about bankruptcy is that in my experience, I have found that most of the wins come from the bankruptcy courts. The thing about bankruptcy is that it has the nice rule, 3001D, Federal Rules of Bankruptcy. 3001D, evidence of perfection of security of interest. If a security interest in the property of the debtor is claimed, the proof of claim shall be accompanied by evidence that the security interest has been perfected. It requires the lender to provide proof of claim. This means that the table is suddenly turned. It is now the lender who has to come up with the proof of claim, and if you know how their fraud is being perpetrated, then you know how to object and deflect their deception. And so that's going to probably be your best option right there if I had to guess, right? File for bankruptcy and then make them prove that they in fact securitized everything properly, and that, or maybe that they didn't, right? So what many people do after they file for bankruptcy is to file an adversary proceeding. As a debtor, this is absolutely free. An adversary proceeding is like a normal civil action, but done under bankruptcy court and under bankruptcy rules. It allows the debtor to challenge the bank to provide proof of standing. The other thing many homeowners do is file their house as an unsecured debt. This will then prompt the lender to complain, but in doing so, they are then required to provide proof of claim, which they often are unable to do. Please note, you cannot file an adversary proceeding under Chapter 7. This is very important to remember. Navigating the bankruptcy process is not for the weak-hearted, even for someone who has a lot of experience in legal procedures. I seriously highly recommend that you get competent help. Look, I am here to save you money. If I highly recommend something, I mean it. Some things you can cut corners with, but bankruptcy is something I don't recommend that you do on your own. Trust me when I tell you that I tried to do it myself, it was a disaster. I wish I had professional help. Normally, hiring a law firm to handle your bankruptcy costs from $2,000 to $4,000 from Chapter 13. We found a company not related to us that specializes in preparing bankruptcy documents for foreclosure defense who can do it for less than $1,000. There are many specific details a bankruptcy specialist who knows about foreclosure defense can help you with that a normal bankruptcy attorney cannot. They will be able to help you with such things as specific methods for declaring your assets and how to keep you in your house for months, if not years, while you go through the legal procedures. If you are interested in this service, and there's a link here, so ask for the book and you can get that link right there. In the next chapter, we go into the practical matter of, now I know that there is fraud going on with my house, what can I do about it? So the practical matters here, what do we got here? So in this chapter, we go through specific practical things you can do right away to challenge your lender. At its heart, there are 4 classes of people that are affected by foreclosures. Number 1, someone who is about to lose his or her home in a non-judicial state, California, Nevada, Arizona, Oregon, Washington. Someone who is about to lose his or her home in a judicial state, New York, New Jersey, Ohio, Florida. Someone who has already lost his or her home. Someone who is hanging on by their teeth, who is upside down and can no longer pay their mortgage, trying to get a loan modification, or someone in good standing. Each class of person has different options and procedures available to them. This chapter will outline in brief some of those options. Of course, this is just a book and is no substitute for competent legal advice, so please consult before doing anything that could affect your home. Non-judicial state homeowners. Most western states of the U.S. are non-judicial states. In these states, foreclosures are governed by the state civil code. These homeowners have it the toughest. Being in a judicial state, lenders need not prove anything. They can simply notify the homeowner of the default. Then after a certain number of days as defined under state civil code, the property then proceeds to a trustee sale at a public auction. The only option available to you if you are in a non-judicial state resident is for you to file a civil action against your lender to compel them to provide proof of claim and therefore standing. The other option is to declare bankruptcy, also known as BK. In bankruptcy, generally speaking, you have 2 options: Chapter 7, no asset BK, or a Chapter 13, asset BK. What some homeowners do is declare Chapter 7 and list their property as an unsecured asset and wait for the lender to object. This then puts the burden of proof on the lender. If your loan was closed with a lender A, and is being foreclosed by lender B or C, there must be by law a valid chain of assignment to show that the lender C is the real and beneficial party of interest. As we discussed, because of the problem of securitization, this is never done. This creates a real problem for the lender, who is frankly doing this in fraud anyway. And that does actually seem like a pretty damn good idea right there, to be honest with you. Because then when you claim it as an unsecured asset in your fucking asset list, whenever they ask you, you know, what property it is that you own and things like that and what the value is, you can go ahead and do that. That's going to put them in a position to go ahead and try to claim that they own it. And when they do that, that's when you fucking got them by the fucking throat right there. You know what I'm saying? Because they really cannot prove that. And if they think that they're in a position to do that, then they're going to have to show the chain of transfer and the chain of title. And then, you know, they're pretty much going to have to pull up their skirt right there for everybody to see what's under there. So, I mean, it does sound like a pretty good option, to be honest with you. So, for those who deal with a lot of assets, such as equity in their homes, they can do a Chapter 13. Under a Chapter 13 bankruptcy, you can file an adversary proceeding where you sue your lender to compel them to produce valid proof of claim. The beauty with the bankruptcy court is that you have the law on your side. Rule 3001D of the Federal Code of Bankruptcy requires that your lender provide evidence of the perfected title. If you choose to file a civil action against your lender, you better have proof, as we discussed earlier. The best proof you can bring is a securitization audit to prove that your loan has been securitized. Then work with your lawyer to build an argument around the points outlined in this book. Unfortunately, this will set you back a minimum of $5,000 and is more closer to $10,000 to $25,000. Alternatively, if you cannot afford a lawyer, you can try and do this yourself. A great place to start is livinglies.com. This is a blog created by a lawyer with lots of articles, sample pleadings, and lots of other resources. Another option is to join our foreclosure defense membership program. We realize that there are so many homeowners needing help. This is why we developed a coaching membership program with specific information and resources to help homeowners with their foreclosure defense. And so it goes into what some of the things that they offer there. So a good place to start if you are in a non-judicial state is starting to write your lender a demand that they produce valid proof of claim. You can find a couple of sample letters on our site, and this will be a good place to get started. And I told you I'm actually starting to put together some documents similar to this as well, because you do want to reach out to them prior to suing them and give them an opportunity to prove claim beforehand. And then if they don't, which they most likely won't fucking be able to prove that they are in fact the holder in due course, even for that matter, to even be sending you bills, then you can go ahead and file suit at that point. So I'm gonna go ahead and leave this right here. I'll get back to another video shortly. Remember, this is a game of chess. Stop playing checkers with these clowns. And that's what I got for you for now. Until we meet again.